Welcome back to the Collaborative IEP Podcast. I'm Ashley Barlow, your host, and I am so happy you're here. And today we are going to carry along in our special podcast episodes, a special podcast series, let's call it, about these policy changes and kind of threats to the Department of Education and to laws and policies that impact the disability community during the Trump administration, and in this case, a little bit prior to the Trump administration taking office. So this episode is dedicated to that case that we know is threatening Section 504 of the Rehabilitation Act. And that case is called Texas versus Becerra. And then parenthetically, I would say now Kennedy. And we're going to talk even about the style of the case. Kind of the long and short of this episode is that the threat to 504 seems to be kind of on the back burner. And I want to say that to everybody to give you a deep breath, the opportunity to exhale. But here's what I want for you to know. I read the case. I not only read the case, but I read everything that's been filed since the case was filed in September, including the most recent update. And I will read the update that comes out on presumably April 14th, or at least by mid-April. And I will continue to keep you apprised of this because I think it is important to do so. So the bottom line is, at the moment, it seems as though this is on the back burner. That could be a good thing, could be a bad thing, but it's also important to read the case so that we understand what 504 does, how 504 impacts and helps students with disabilities, and why there's so much hubbub around this. So we're going to dive into our special episode now, and welcome. Thanks for joining us. Okay, so when we went through the inclusion document in our last two special episodes, I walked you through page by page because I think it's important that you read that document. I don't think it's as important that you read this complaint and that you read the additional information. So I'm not going to walk you page by page through this document. I'm certainly not going to reference certain pages of it is to the extent that I do in that inclusion doc podcast. But I do want to kind of walk you through in approximately the same order that the case goes, because I think it's important to follow it along so that we can follow the arguments that are made. For a second, we're going to start off, and I'm going to give you some context on Section 504, what 504 does, why this case was filed, et cetera. And I think that'll help us to really understand the risk to 504. So I'm actually going to jump around in the case a little bit, but I'm going to be speaking from the case so that you can kind of follow the arguments that are made by these 17 states. Okay. So generally speaking, here's what's happened. On September 26, 2024, back when President Biden was the president, 17 states filed a lawsuit against Xavier Becerra, who was the Secretary of HHS, the Agency for Health and Human Services in the Biden administration. Robert F. Kennedy is now the Secretary of HHS, and that's why parenthetically I would call this case Texas versus Becerra, now Kennedy. Okay. Why do we say Texas? The reason we say Texas versus Becerra is because Texas is the first state on the style. So when we look at a case, there can be many plaintiffs to the case. And in this case, there are 17 plaintiffs in this case. That means 17 states have sued the Department of HHS relative to a complaint that they have regarding Section 504. Those states include Texas, Alaska, Alabama, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Louisiana, Missouri, Montana, Nebraska, South Carolina, South Dakota, Utah, and West Virginia. You will notice that Texas is the only one that is not in alphabetical order, and I suspect that that's because Texas's Attorney General took the lead on this and gathered up all of the other states. You can search another Texas versus Becerra case. There's another one that has to do with a totally different issue. There might be more than one, but I would caution you that if you look for this case, and I'll put it in the show notes, but that you find the one that has to do with 504 so that you're reading the right thing. Okay, so the gist of this case is regarding the definition of disability under Section 504. So basically, Section 504 is a law that provides protections for people with disabilities. And so we have to define the word disability. Generally speaking, what 504 does is it prohibits discrimination on the basis of disability. And so in entities that receive public funding, and we're going to go through a lot more specifics here in just a couple of seconds, but on May 9th of 2024, what happened was the Biden administration changed the definition of disability in order to include gender dysphoria to that definition. And that is really the problem here. That is actually what these 17 states are saying they disagree with. The issue from the disability community is that they take their problems wider, and therefore this lawsuit could have a really detrimental impact on the disability community. Okay. Um, how did the Biden administration do this? Well, this is agency law. And just like we've talked about how there's a risk that the Trump administration could change things within the regulations in order to promote their policy, this is something that the Biden administration did by way of administrative regulation, which is controlled by his agencies, by any government's agencies. And so they did it by regulation. So this was a new rule. They regard this a lot, that the quote is new rule. And so the new rule changed the definition of disability so as to include gender dysphoria. And what that means is now, according to this new rule, any agency or entity that receives public funding cannot discriminate against someone on the basis of gender dysphoria, because gender dysphoria is categorized within that definition of disability. So it then becomes extremely important to understand what 504 does. So let's look a little bit into the history and the meaning of Section 504. Okay, so whenever I hear something like Section 504, I'm like, of what? If it's a section, then what's Section 1 say? And above that, what's the title of this thing? So when we talk about Section 504, we are talking about the Rehabilitation Act of 1973. Yes, we are talking about a law that is older than me. A very well-established law. And within the Rehabilitation Act of 1973, there is Section 504. And I'm going to read you a quote from the law because I think it's important here. No otherwise qualified individual with a disability in the United States shall, solely by the reason of his or her disability, be excluded from participation in, be denied benefits for, or be subject to discrimination under any program or activity receiving federal financial assistance. And it later says that Section 504 applies specifically to programs receiving federal funds, executive agencies, and the United States Postal Service. And of course, schools therefore are qualified to or are in need of following 504 because schools get federal funding. Okay, so that's the basis of the law. There is a little tease out about the ADA because they try to make differentiations about the definition in ADA. ADA applies to more entities because there isn't the requirement for federal funding in the ADA. But they share the definition of disability, and that's the important thing. So disability under the ADA and the Rehabilitation Act of 1973 define disability as an individual. Well, so they define disability by talking about a person. So a disabled person, in my opinion, kind of like adding a little context, is an individual with a physical or mental impairment that substantially limits one or more major life activities. Number two, or they have a record of an impairment that substantially limits one or more major life activities. Or number three, they are regarded as being a person that has such an impairment. Okay. So they either have a disability, they have a record of that disability, or they are regarded as having a disability that limits one or more major life activities. Okay. So that's the context of the law. So basically, from a general kind of top level perspective, they are saying that when Congress wrote 504, it specifically accepted people with gender dysphoria from the definition. And they also say that is true of the ADA. So it says it established it as a matter of law that transvestism, this is a quote, transvestism, transsexualism, and gender identity disorders not resulting from physical impairments or other sexual behavior disorders were considered by Congress back in 1973. And they said, no, we're not going to include them in the definition of disability. The final rule, this new rule, also obligated three additional things, and they think that those three additional things are overreaching. So the three things are as followed. One is that anybody that gets federal funding has to provide services in the most integrated setting. And we're going to hear arguments relative to these things in a second. But the first one is this most integrated setting requirement. The second one is that they have to prohibit actions that result in, quote, serious risk of institutionalization. And so that has to be prevented. And we're going to hear that ties kind of into Medicaid. We're going to hear about Medicaid in a second. And then number three is they have to allow discrimination claims to be brought when no institutionalization or segregation has actually occurred, but when it's just threatened. And there's going to be an argument about that as well. So those kind of tie into our general provisions. Basically, they're asking that this final rule be set aside, but then they're asking for a little bit more, which is one of the things that impacts that could have a really detrimental impact on the disability community. So now a little bit about Medicaid, because Medicaid ties in here as well. So Medicaid, as you know, is funded by the federal government. And Medicaid is optional for states. States do not have to take Medicaid. But in order to get the federal funding, of course, just like IDEA, when they get, or, education law, when they get funding from the federal government, they have to agree to follow the rules. So traditional Medicaid is what we call a medical model or an institutional care program. So the money that comes from the federal government is this medical model of healthcare that has this kind of like institutional component to it. You probably know about waivers. Most states also can opt into Medicaid waiver programs. Medicare waiver programs are, my first question when I heard about waivers in Kentucky was, well, what are you waiving? So you're waiving that institutional care component of Medicaid in favor of community-based services. So we're going to hear, as you can imagine, when you heard about those three new things that this final rule does, we're going to hear about this requirement that people are, number one, in the most integrated setting. Number two, that we have things regarding risk of serious institutionalization. And number three, that we can say discrimination has occurred even if no institutionalization has happened and no segregation has happened, right? Because that is a pretty broad definition of that law. Okay. Now is a really good time to stop and say, I don't know, we're 15, 20 minutes into this recording, and you see that I have only said the word school once. At this point in my reading, I'm only on page 6 of the complaint, but I was like, my thought was that they probably did not know the impact that this would have on schools. Right, wrong, or indifferent, it's okay to say they might not have known, right? Now, there are, in fact, I'm not excusing that behavior. Let's be clear. There are things that our legislators need to know. But at this point, I did a little control find and looked for the word school in this document. And school is only in this document 2 times, and it's within the word preschool when it talks about funding in the very beginning. So it is my sophisticated guess that when these attorneys general and folks worked on this thing, they were really only thinking about the LGBTQ community, LGBTQ plus community, and they were not thinking as much about the impact on school children. Again, you've heard me say this 1,000 times, but this is why grassroots advocacy matters. This is why the disability community speaking up really made an impact, because eventually the end of the story is they said, hold on, let's gather our troops and take a break from this and see if we can come up with a better solution. Now, that also has to do with some of those anti DEI executive orders, and we're going to hear about that in a second. The other policy or like fundamental values statement that I'm going to say at this point before we dive back into the case a little bit more is one of the things that, and this is, I try to keep these things pretty neutral, and this is a little bit less neutral. So bear with me here for a second. But one of the things that has really impacted me as a human by way of raising a person with a disability is being adjacent to a marginalized group, right? My child has a disability and he is marginalized. And that has in turn made me more empathetic to other marginalized populations. My child has been raised in a political environment where marginalized communities are really kind of looking at regression in federal and state policy after years and years of progress. When you look at the fact that the ADA is making its 50th anniversary at the end of this year, and we are still looking at regression in things like laws that affect school and regulations that affect school and public policy that affects school children, and that's school alone, right? Medicaid is being threatened by the government's budgeting and all of these things. It makes me as a human much more empathetic to people in other marginalized populations. So, when we think about, oh, well, that really just applies to the LGBTQ plus community, and the disability community got kind of like tagged on to this lawsuit or impacted by it by accident. I don't think in my soul I have come to the value, really. This is a value that I have really deepened over the course of my life in raising Jack. I don't think that that's necessarily fair. I feel like we're all in this together, and if there's one thing that I have learned in educating Jack and raising Jack, more importantly, and loving Jack, it is that there is space for all of us in our beautiful uniqueness in this world, and we've got to stick together. So while I really endorse the grassroots efforts of the disability community, I furthermore endorse the grassroots efforts of all marginalized populations, and I truly do believe that we need to stick together. So now we will get back into this case. I just got to argument number one in the complaint, and I'm laughing to myself. So before we dive in, I'll tell you that I read this on a plane next to like a 20 something who was trying to like work much more peacefully than I was working as I was like enveloping this case. And when I read cases, I'm constantly flipping like back and forth. So I make sure that I understand the way the arguments are tracking and whatnot. The complaint alone is 46 pages. And so I had two different stacks of like have read, still need to read, plus my laptop balanced on my lap on an airplane. And I could tell that I was really annoying this guy. And then hilariously, I like the green lifesaver mints, and those are like a treat for me because I don't do a ton of sugar, but I always take them on planes. And so I got like a little handful of them out, and the guy started coughing, and I was like, "Oh gosh, I just cannot satisfy this." Like, so I'm reliving that as I am flipping through these pages. But the good news is I'm going to go from page 7 to 15 in a couple of sentences or less. So basically, we've arrived at the part of the complaint where we learn what the four main arguments are of these 17 states, and saying that 504 should not have been broadened to the extent that the Biden administration broadened it. And the first argument is basically that gender dysphoria is psychological in nature and it's not physical. And as a result of that, it cannot be tested and therefore does not match the definition of disability. And I think that's enough for argument one. So that's argument one. We can move on to argument two, which is a little bit more complicated. There's an A and a B. And the heading of argument two is that HHS's quote integration mandate exceeds statutory authority and just goes too far. So remember I talked about the new component to it that there was this integration. And what that does is it requires every recipient of federal financial assistance to administer a program or activity in the most integrated setting that is appropriate to the needs of the qualified person. And then they have a definition of what the most integrated setting is. So there's an A and a B to this argument. A is about Olmstead. Olmstead was a Ruth Bader Ginsburg decision. And basically, the argument is that this integration requirement runs counter to Olmstead. Okay, so it's important then to know what Olmstead is. So, again, the argument here by the states that are trying to carve out or even do away with 504 is that these new rules do away or run contrary to the principles in the Olmstead decision. Olmstead is a 1999 case that was heard all the way up to the United States Supreme Court. And Ruth Bader Ginsburg wrote our decision. It is a seminal case in the disability community. So basically, Olmstead was about two ladies, I think they were in Georgia, who were in and out of institutional care. They both had mental health conditions. And so they would go to an institution, they would go back home, they wouldn't have supports, and they would go back into an institution. And the argument was made that the ADA, of course, was established in 1990. And so the argument was made in Olmstead that those people should have community supports as opposed to going in and out of institution. So rather than going in and out of institutions, they should have consistent community health supports and mental health supports, and that then they would live more full lives. And the decision ultimately in Olmstead, it was granted, I think, at the district court level and then appealed and successful on appeal. And that's how it ended up at the United States Supreme Court. And the decision in Olmstead was yes, people with disabilities should have available to them community support so long as three conditions are met. And the three conditions were something to the extent of the doctors say it's okay, maybe like the individual with the disability says it's okay, and I don't like a third, right? And what the argument is here in this Texas versus Becerra case is that what it says is requiring them to design or redesign their systems and programs for individuals with disabilities to eliminate practices that result in serious risk of institutionalization is overstepping of Olmstead. I don't know if that is true. I actually think that this runs like completely parallel to Olmstead in my interpretation and my learning of Olmstead. It's one of my favorite cases that I read in law school, and it is the first thing that I read when Ruth Bader Ginsburg died. Was I read through the Olmstead decision. Okay. Remember how I said there was a part A and a part B to this second argument? The part B is that the at risk theory you heard in the definition of, those three additional things, that there was this at risk of institutionalization. And basically, they're saying that allows people that are merely at risk of institutionalization to claim discrimination, and that would be too broad. So there's a kind of like tease out or wordsmithing that happens there with that at risk. So now we can move on to their third argument. And basically what this is these 17 states being worried that they have to provide unlimited community-based services or risk a lack of funding. So, what waiver services do again is this is why the Medicaid argument came in. So waiver services allow for services in communities. And basically, what we learned in Olmstead and what Medicaid's position is now is that it is less expensive for Medicaid to pay for community living supports than it is for Medicaid to pay for institutionalization. And so, what they're saying is, okay, so community living supports, if those have to be completely unlimited, that could be extremely expensive. And we're worried that this broader definition makes community living supports impracticable for states to run. And then to really hammer that home, they complained state by state. So, argument 4 is that there is a quote, legitimate interest of federal grantees, i.e., state, in preserving the integrity of their programs. And they literally go state by state. So, first of all, Texas lists their inconveniences, and then it goes state by state. Some of them I literally wrote in my margin, "Gasp," because some of them are just so egregiously discriminatory against people with disabilities and people in other, and people in marginalized groups that qualify as being disabled. But, one of them is having to make an accommodation relative to people's pronouns, as though that would be such a horrendous burden on a state. I'll go ahead and read you a quote from the paragraph on Texas, and then I think there are some additional valid points and some things that could be teased out if we do, in fact, end up looking at 504 in the future. So I'll go through a little bit of this tedium with you, but I will spare you what every state said. And by the way, a lot of them are copy and pasted from state to state. But one thing that Texas said is, here's a quote. Such accommodations likely include using employees' preferred names and pronouns that do not align with their biological immutable sex, allowing employees to dress as a member of the opposite sex in violation of dress codes, prohibiting unprofessional and inappropriate clothing. I mean, I don't know many organizations that still have dress codes, honestly. And allowing employees to use sex segregated bathrooms and locker rooms that do not align with their biological and immutable sex. This becomes pertinent because one of the reasons this thing is on hold is because they have said in a proceeding that President Trump has issued those series of executive orders that prohibit things like gender neutral bathrooms. So this anti DEI executive order kind of series that he issued. And so they're like, those could have taken care of this 504 tease out anyway. Let's get our ducks in a row and get back. So it does all kind of tie together. Another valid point was made in the Alaska paragraph. And what Alaska indicates is that they have a unique, quote, unique frontier geography and demographic characteristic. And that would be hard to provide services to everybody in a community setting. Like if you're in a big city in Alaska or even a decently established community in Alaska, community living supports would be fairly easy. But I know I represent a lot of students that are in rural Kentucky. And literally, when we go looking for services, I will draw a map that is a 1.25-hour commute around their community. And that only might be like 30 or 45 miles because they live in such remote communities. And so, in Alaska, if you watched any of those cool reality TV shows, you know that they go from community to community in airplanes sometimes. So it would be really difficult. And we've got to think about all 50 states when we do federal legislation. So that is an interesting point. Another good point is that CMS services, our Medicaid waiver services, have very long waiting lists. They have enrollment caps. Like, oops, I did my thumbs up counting, and a little thumbs up came up on my video recording. So there's enrollment caps, there's really long waiting lists. And another kind of thing that gets in the way is that currently the waiver rules don't allow the aggregate waiver amount to amount to more than the cost of nursing home care or institutionalization. So your community living supports do in fact have to be cheaper than the cost of institutionalization. Most people that I have represented and asked about waivers, their budgets range from, anywhere from like $20,000 to $65,000 a year. And as we know, nursing home care is a lot more expensive than that. But it is a valid point and something that if in fact they do decide to open up 504 revisions might be something that they look at. Then there's a really interesting piece when you get to Nebraska, and that's a last little tease out here. And I don't raise this for any discussion or opinion on the Nebraska law, but rather for an interesting tease out. So Nebraska's governor issued let's see, I guess it's an executive order that, you define sex as your biological sex. And there's another law in Nebraska called the Let Them Grow Act that limits gender altering procedures and gender affirming care for Nebraskans under the age of 19. And so in their argument, what they're saying is if we were to follow 504 with this new definition of disability, that would run counter to state law. And the point I want to make here is that is a good point that, federal law trumps state law. And, there are many people in the United States that feel like the federal government is too big and that states need more autonomy. And certainly this change in disability definition does highlight the way that the federal government gets in the way, so to speak, of states' abilities to do things, to legislate. So whether or not you agree with it, it is simply a point, and we will leave that there. Because my opinion relative to that is not the topic of this podcast. I told you that the compliment that I get oftentimes after these things is how I'm able to do them without inserting my opinion in a way that is distracting. Okay, so then we come to the part of the complaint that is called claims for relief. What do we want here? And this is where the majority of the problem lies. So, ask number one is please hold this new final rule as unlawful and set it aside. Ask number two is it is arbitrary and capricious and set it aside. Arbitrary and capricious basically means we don't understand it. It just don't make sense, as we say here in Kentucky. Ask number three is the big problem. Get rid of all of 504. This is interesting, and I want to read it to you because it comes up here in a second. So, what they say is that 504 in its entirety is unconstitutional. That is a very bold statement to make. And that is the statement, the ask that has the disability community up in arms. So I've got three little notes here. They kind of make three different arguments relative to their assertion that 504 is unconstitutional. The first one is that states don't really have a choice in receiving federal funding. So, in other words, states need federal funding for all sorts of things. And in exchange, they have to follow the federal rules. We know that because we're walking through IDEA right now. But what they're saying is these rules, in their opinion, are ambiguous and add new conditions to the agreement, so to speak, that's between states and the federal government. Okay. Then the second argument that they make is that the conditions are not related to a federal interest, and that's kind of a requirement constitutionally, in particular, national progress projects and programs. So therefore, it should be stricken. 504 should be stricken altogether. And third, the law requires states to regulate, and that violates sovereign immunity because states should be able to regulate. And so in section or number 239, it says because 504 is coercive, untethered to federal interest in disability, and unfairly retroactive, the Rehabilitation Act is not constitutional under the spending clause. And what they say is don't withhold our federal funding in order to, if we don't comply with this new definition of disability and these three new rules. The argument that 504 is constitutional is in fact the thing that got everybody up in arms because 504 cannot go away. That would have a horrendous impact on students with disabilities. Okay, moving on to argument four, what they say is that this new definition and these new three rules are unconstitutional because they are ambiguous. And then at the end, it's signed by 17 states and a bunch of their attorneys general. Now, it is maybe of note that some of these include pro hoc vice. A lot of people have asked me what that means. That means if you're not admitted to practice in a particular bar, like a state bar or a federal bar, you have to apply and you have to get sponsored to practice there on a limited basis just for the purpose of that case or for, a series of cases that have the same thing or something like that. So that's why they're pro hoc vice. Then there's I looked through the filings. There's a bunch of orders approving a bunch of people's pro hoc vice application. There are also a bunch of transactions that have happened in this case where attorneys have subbed in and out for people. I didn't look too terribly into it. My sophisticated guess is that some of those people rolled off out of their attorney general jobs in December and January when elections and inaugurations happened and new administrations came into state government. And that maybe even some states hired special counsel to proceed with this case by and through the attorney general. I don't know that. That's a suspicion, but that's just my sophisticated guess. Okay. The next thing that we see is okay, so that's the complaint. It's worth saying that the impact of this case would have a horrendous impact on students with disabilities in schools. And that is why you saw the outcry of the disability community saying, hold on, stop, something's got to change. This law, this case cannot move forward, and 504 needs to remain intact, right? Then we've had a few updates. And so I want to give you the updates because I want for you to know exactly what is happening. So we got a document that was filed in January of 2025, and it is a scheduling order. So federal courts, like if you go to state court, I mean, at least in Kentucky, you have to do like a scheduling a case management conference where you go in and you schedule like approximately when do we think we're going to have trial and what's the next step and how's your discovery coming and blah, blah, blah. In federal court cases, that all just happens. Like there's a rule or a regulation or something. I guess it's a civil rule where you have to do a scheduling order and it's got to be done in a certain timeline. So that's pretty rote. That's what's there. But then we see something really kind of exciting for the wrong reasons that was filed on January 24th of 2025. And basically what happened was HHS, which was at that time run by, actually it was still Becerra at that time. I just double checked. It was still run by Becerra, but then soon thereafter, Kennedy was confirmed as the secretary of HHS. So HHS said basically that President Trump had signed that executive order. And so basically, can we stop these proceedings and regroup? Because we now have an executive order that prohibits DEI practices, and that would apply to these agencies that are getting federal funding. So what's interesting about this is, sometimes I call things a good bad, and this is a good bad because the executive orders are going to work to the detriment of students with disabilities. We see that already in the actions that the Office of Civil Rights is taking within the Department of Education. So the executive orders that have this anti-DEI perspective are by and large working to the detriment of students with disabilities in America. But in this particular case, they could work to our advantage because this case could go away and they could try to attack the definition of disability in Section 504 by way of a different means. Or they could tease it out differently still within this case, but it is clear that they have heard from the disability community that the impact on students with disabilities would be significantly detrimental. And I think this sentiment is fairly widely agreed that these 17 states and no other people intended to carve out or to do away with protections that were available to students in schools under 504. The other kind of interesting thing to note here is that we used to have plaintiffs versus defendants, right? So it was 17 states versus HHS and the Biden administration because of this rule. That rule, of course, goes from administration to administration. Now we've got somebody new in office and they're saying, hang on a second, we agree with the executive branch. We agree with the executive order. Interestingly, HHS is within the executive branch, but HHS still has this rule that came from the prior administration. So now they're saying we agree with the president, but we still want to tease out something that is in the agency that is under the control and command of the president of the United States with whom we agree. So just kind of interesting. And then we see the last update, which was October 19th of 2025. This is when our style changed to Texas versus Kennedy because Kennedy was the secretary of HHS. And this is a joint status thing. So now we've got these 17 states and HHS filing something together. And what they're saying is, can we please all have time? Can the 17 states have time? And can the federal government have time? And they offered, will update monthly. Now, here's something else interesting that they said. They were like, hey, by the way, we never intended to get rid of 504 altogether. We never intended to declare it unconstitutional. Literally, the header of argument number 3 was 504 is unconstitutional. But they said, oh, by the way, we didn't ask you to declare 504 unconstitutional, and we haven't asked you to stop funding 504. Very interesting. but that is an acknowledgement that they heard loud and clear from the disability community. We get an order from the judge saying, that's fine. You don't have to update me monthly. Update me again by April 21st. I think I said the 14th, April 21st of 2025. So we can expect our next update to be April 21st, 2025. My experience in having worked for the government, I prosecuted child support for a while, is that court cases and government entities work very, very slowly. So I would expect for the update at the end of April to say, everything's the same, give us another 2 months. But the Trump administration is working very quickly and is filing these big, boisterous things to get people up in arms, to get everybody overwhelmed. And, I guess from their perspective, to try to make government smaller and to promote these anti-DEI things and to follow their interests and values in court proceedings. And so it's definitely something that we want to keep a close eye on in the disability community, because we don't want to let 504 be impacted negatively at all. Oh, just a little light reading. That was about a 2-hour stint of my plane ride out to California for the COPA conference. As always, I would very much appreciate your feedback on these things. If I had the time to actually outline them and make you slides and do that, I know that these would be more helpful, but I'm still getting good feedback that my rambling and paging through documents is helpful to you. So somehow it seems to be working, but I would appreciate any questions, comments, compliments, or criticism, because that'll help me get you what you want. I will see you for our next special episode. I do have one planned on additional changes within the Department of Ed, such as the reduction in size of the staffing and that sort of thing. So stay tuned for that.